go to 7.2, which is an introduction and first reading of an ordinance about administrative citations. Michael Gina.
Good evening, Mayor and members of the Council. I have a brief oral presentation, no PowerPoint, for this item, and I'll run through it fairly quickly. The proposed ordinance before you would add a new Chapter 7 to Title 1 of the Emeryville Municipal Code regarding administrative citations. The chapter would provide for the ability to issue administrative citations and penalties for violations of the Emeryville Municipal Code. The ordinance would allow violators to request an administrative hearing before a neutral hearing officer before imposition of any fines or penalties. As a way of background, pursuant to its constitutional police powers, the city has enacted a number of codes to protect the public health, safety, and welfare. The issue before us is regarding...
Hang on a sec, sure. Michael. Can you clear the foyer so we can hear... That could have been your first job, Dave, in a...
Great. Yeah. So the issue is enforcement of those codes and ordinances, and the municipal code currently doesn't provide for the ability of city staff to issue administrative citations. This proposed ordinance would add that additional tool in our toolbox to allow for administrative citations, where the penalty is monetary fines and penalties. This ordinance, the issuance of administrative citations, again, is one tool in the toolbox of code enforcement. It's not something that we would apply all of the time. It's applicable to those violations and violators where a monetary penalty hitting them in the wallet will cause the violator to come into compliance. It also allows for an administrative hearing so that if the city didn't get it right, that the hearing officer would be able to judge whether or not there was in fact a violation of the municipal code. The way that let me just walk you briefly through the way that this process would work. If the city code enforcement officer found that there was a violation or felt that there was a violation of the municipal code, the first thing that they would do would be to issue a notice of violation to the responsible person. That notice of violation would specify the municipal code in question, the violation that is purported, the time, place, and manner. It would also specify how the violator would be able to come into compliance and would allow the violator a reasonable period of time to correct the action. This would all be done prior to the issuance of a citation. It's a warning, essentially, and it gives the violator notice that there is a problem and gives them an opportunity to correct it on their own. If the responsible person does not comply within a timely period, the code enforcement officer may then issue an administrative citation. That citation would order the responsible person to correct the violation, again within a reasonable period of time, and would provide for penalties that are in a penalty schedule for non-compliance. If the responsible person feels like that there is no basis for the violation, or the notice of the administrative citation was issued in error, the responsible person can then request an administrative hearing. The hearing would take place before a hearing officer who would be a neutral third party who would essentially hear the case. The city would have the opportunity the citing officer officer would have an opportunity to present the city's case, specify what the violation was, the notices that had been provided, any compliance or lack of compliance, and would be able to provide pictures or other evidence that would help frame the picture for the hearing officer. The responsible person would then be able to respond to the allegations that had been stated in the administrative citation, and the hearing officer would then be able to issue a decision based on the evidence that was presented. In terms of the decision issued by the hearing officer would be able to affirm the citation and require the responsible person to pay the fine. The hearing officer could dismiss the citation altogether, finding that the city didn't have a basis for issuing the citation in the first place, or the hearing officer may reduce the fine or otherwise provide for if, for example, the responsible person had complied in part but not in whole, there could be a further reduction in fines based on the decision of the hearing officer. That hearing officer would issue the written citation within issue a written decision within 30 days after the close of the hearing. The ordinance also provides for summary abatement. So if there is a condition that threatens the immediate health, welfare, or safety of the city city could also conduct a summary abatement of the property without having to go through the administrative hearing process. And again, these are in extreme examples where there is imminent danger to public health, welfare, or safety. As for the collection of fines and penalties that would be imposed, if the responsible person did not pay the fine in a timely manner on their own, those fines could be sent to a collection agency. In the case of property-based penalties, so if there is a code violation relating to property, real property in the city could also impose a lien on the property, and that lien and the imposition of that lien would come before the city council. And the council would then be able to weigh in on whether or not a lien would be assessed against the property owner. In terms of the legal considerations, the staff report talks about, just briefly touch upon that. This is a tool regarding code enforcement which is fairly common. It's found in many other local jurisdictions as a tool for code enforcement. There is an appropriate balance here between the city, which is able to issue these citations and penalties, and due process that's provided to the responsible person. They're provided notice of the violation. They're provided an opportunity to correct the violation on their own. They are also provided an opportunity to appeal any citation that's issued before, and have a fair hearing before a hearing officer. So due process protections and notice are appropriately provided to the responsible person before any fines or penalties are assessed. Lastly, I'll note that the Community Preservation Committee had considered this proposed ordinance in its meeting back in October, and they had recommended that the City Council approve and adopt the ordinance. So with that being said, the recommendation is that the ordinance be introduced after a motion to read by title only, that you take public testimony regarding the ordinance, and then you afterwards adopt the first reading of the ordinance. That's the conclusion of my report, and I'm available for any questions.
Questions? Yeah.
I have some clarifying questions. In terms of summary abatement, I'd like to know who decides that there's an imminent danger. Is it one person? Is it brought before council? And again, for summary abatement, do all of the notifications apply?
So in terms of who decides, it would be it would not be the city council. It would be the code enforcement officer. And when I say code enforcement officer, it is the officer in charge, the officer who applies the codes that are applicable to the particular situation. So in the case of a dangerous building, for example, that would be the building official who would be applying the building codes. In the case of a potential fire hazard, that would be the fire chief, who would be applying fire codes in relation to a particular building. So if the city official who is in charge of administering and enforcing those particular codes relative to the building or the situation in question feels like there is a imminent danger, then at a staff level there would be a determination that there is an imminent threat to public health, welfare, and safety. Now, what will happen, I think, on a practical level is that it will be it will be that city official in conjunction with the city. I'm seeing the city attorney's office being brought into this, and other affected departments as well. So in answer to your question, it is at a staff level determination. Notices will be provided if practical. It's always our preference to be able to give as much notice in advance to a responsible person so that there are no surprises on their part. If, however, circumstances, you have a building that is, there's been an earthquake and the building is about to fall down, and it's been red tagged, you can't find the person, then the city may do a summary abatement without notifying the responsible person beforehand, but will certainly take every effort to contact that person afterward. So I guess the short answer is the amount of notice that will be given in advance will be dependent on the nature of the violation and the circumstances of the imminent threat and danger.
Well, I guess I'm wondering, how do we codify that we are indeed going to make our best efforts to let a person know if we're entering their property and fixing things up?
Well, the ordinance provides, I'll point you to, in the proposed ordinance, section 1-7.13 sub A calls out that the enforcement officer shall make every effort to make contact to the responsible person by a variety of methods prior to the abatement taking place.
Okay.
Yeah.
Yeah. What if somebody is poor, that is, they
Yes.
can't fix their house, and then we bring them into an administrative hearing and then tack on fines?
Sure. So, as I said, this is a tool and a tool that may not necessarily be used in every situation. The imposition of fines and penalties works best when you have a violator who has the means to pay the fine and who is willing to do it. So in a situation like you're describing, perhaps the imposition of fines one after the other to a person who doesn't have the ability to pay them is not the tool that we would use. Whenever we go into a code enforcement situation, we're always looking at, how one of the things that we're considering is which enforcement path do we go down, because it doesn't do the city any good to be able to, tack on fine after fine to somebody who doesn't have the ability to pay those fines. And so at the outset, at the beginning of any code enforcement effort, we would then, in terms of looking down the road as to how this would play out, we're looking to see which code enforcement tool would be appropriate given the nature of the violation and the person that's violating the code. So that's a long way of saying that we would not necessarily impose administrative citations in every case. We would be looking at who the violator is, if there is a potential for recovery. The other thing I will also add to this is that the code, the proposed ordinance also has a hardship waiver that's written in here that allows, so the ordinance provides that if you request an administrative hearing, that you prepay the cost of, those fines and penalties. You deposit them in advance of the hearing. If you can request a hardship waiver, and if granted, you then are relieved from that obligation to deposit the fine or penalty in advance, and you can then proceed and have the administrative hearing without that advance deposit. Regarding the deposit as well, if the hearing officer finds in favor of the responsible person, the deposit is refunded back to the person who had deposited those monies.
Yeah.
Emeryville has been around for, I guess, more than 100 years. How is it we've functioned without this in the past?
Sure.
What have we done?
We have done so. Currently, our current enforcement tools include writing criminal citations to violators, which, depending on whether or not, so the municipal code at the beginning of the code has a table which indicates that violations of the Muni Code may be punishable as either criminal citations or infractions, or misdemeanors. In the case of a criminal infraction, the penalty is a monetary penalty. However, you're bringing somebody to criminal court in order to process that. So that's one current tool that we have. The other tool that we have, we can always bring a civil lawsuit against somebody. That's a bit heavy-handed as well and not necessarily appropriate in all circumstances. There is an administrative hearing process that is currently written in one chapter of our code. However, we find that has been burdensome in terms of its application and not very effective, and we have rarely used it. The bringing of an administrative citation ordinance to you has been a project in the city attorney's office for a while, and it allows us to, again, I keep going back to this idea that it is another tool that we can use. We haven't had it in the past, and in some cases it would have been appropriate if we had it. So it allows us more flexibility in being able to enforce the codes.
Yep.
Could I ask some other officials about this issue, like our city manager? What is your opinion about this? Do you see this as a major cost saver to the city, or anything about it that, from a city manager's point of view, that you would see it as?
I think it just really depends on how it's applied. I don't know how many potential cases we have had that have come forward that where we would have needed this tool, and instead we had to go down a different road that costs additional staff time. So that's difficult for me to answer.
Okay, well, how about our new police chief? Does our new police chief have an opinion about this? Do you see any major cost savings or benefits?
What little I know about this, I think that, as I understood the way it was presented, there's an awful lot of discretion involved with the application of this policy. And I think that's the key to any ordinance that you may enact. But the other issue with that, there's a little lack of clarity. And I'm not sure what you wish to achieve by very limited knowledge based on what I heard this evening. I think that the intent is to put some teeth into this ordinance so that if somebody's abusing complying with the ordinance, you have some kind of an administrative policy that holds them accountable. Now, whether you're going to save money doing that or not, I don't know, but you do have staff time involved. So that's always a factor of any ordinance. If you're going to enforce it, you always have staff that you have to consider in terms of it being a cost associated with. So do you recover all your costs? I don't know. It's hard to tell.
So if I could respond to that. So one way that we were looking at this ordinance would be as an enforcement tool for the minimum wage ordinance, which you just discussed. In the context of an employer who is in violation of the minimum wage ordinance, if an employee has complained about a violation of that, and a hearing has been requested, and the hearing officer finds that there has been, in fact, a violation, then the employer would be subject to whatever fines and penalties had been imposed. As I had said in my previous presentation on the minimum wage ordinance, one of the things that we would be able to do in that case, in the event that the hearing officer finds in favor of the city, is to be able to recover our costs, our staff costs that had gone into prosecuting the administrative citation.
If there are no more questions, is there public comment on this?
Yeah, I'm going to make some comments that are poetically connected to the item at hand. So if you remember your poetry that you might have read in college or since then, bear this in mind. To the Vice Mayor, Ms. Davis made reference just a few moments ago with regard to the small businesses in our town, that there's an individual, the unnamed individual, that had been, what you say, harassing small businesses. That's serious, and that's a crime. To harass somebody is a crime. You can talk to your new chief of police about that. And so I recommend that you tell small businesses to call the police if a crime is happening. Instead of just complaining about it, the police should be called. When criminal actions happen, when criminals enter these small businesses and commit crimes, our police department should hear about it. So I just wanted to, maybe you could tell the businesses that mentioned this about this individual, that this criminal that entered their premises and was committing crimes, tell them to call the police. And then I wanted to also then part from that and just once again to speak to our Mayor Ruthak and thank you for what you've done with regard to the minimum wage. As I said, this is the job of government, and we haven't agreed on a lot of things, and I have said some things about you that were pretty inflammatory. At one point I referred to you as a dark force, and I got to say that after tonight I retract that. You are clearly not a dark force. You're clearly a force of light, and I really appreciate it. I really respect and admire you for doing this. I know it was difficult and took a lot of heat, and I just wanted to say thank you to our mayor, and I'm just really proud of our mayor. Thank you very much.
Is there any comment, other public comment on item 7.2? Okay, is there a motion to read by title only?
Motion to read by title only.
Did I hear a second? So I'll second it.
Yeah.
All right. All those in favor?
Aye.
Aye.
No. But I want to
okay.
say that it's because I appreciate putting this forward and having the administrative citation process, especially with our discussion of the minimum wage. But if we're talking about property violations, my concern then becomes if someone is living in poverty and all that they have is their home and they're unable to fix it, you know, have we built in enough protections for people who are vulnerable in that way. And I also worry about putting liens on people's properties when that may be their only source of wealth. So I appreciate getting the tool in the toolbox for the minimum wage, but I do have a concern with the discussion of property violations.
I'd also like to say that I would support this in relation to the minimum wage, and I'm concerned also about property violations, and you know, just having people's property hauled away and without you know, it could be a slippery slope. I'm concerned that could be a little bit of too much ease of administrative citations I'm concerned about.
And I raised questions about the summary abatement, and I'm uncomfortable with the language that's in here. And but I agree with Councilmember Asher and Donahue that everything that as would apply to minimum wage and easing the burden on that citation process, I do feel comfortable with. I have every belief that any one currently working for Emeryville who would enforce codes would absolutely go through all of the notification process as prescribed. But there may be a day where different people are sitting here at the dais and different people are working on staff, and we would be giving them a blank check to abate if an enforcement officer found it fit to do so.
So, looks like there's 3 council members who have concerns about this. There was a motion to read by title only, which I seconded it, but then after the reading, we can have a vote whether to proceed yea or nay on this. So, or we can pull this. And if you wanted to continue this item to another meeting, we could continue this item to another meeting. So what's the pleasure of the council here, or staff? Do you want to rework this, or?
Mr. Biddle might want to say something, or no?
We ought to just pull it for now.
Yeah, yeah.
Sure.
All right.
And,
so that maybe this will come back later. Maybe not.
Maybe
all right. Now we go on to another light subject. Residential tenant protections and services. And we're starting this at 10 to 10 at night.
That's best for last.
I'm going to take my jacket off for this one.
I might need to get a Coke.
Here we go. Good evening, Mayor and council members. My name is Catherine Fripp. I'm a housing coordinator with the Community Development Department. Today, I'm coming to talk to you with an item about residential tenant protections and services. A little background, residential rents in Emeryville have been increasing for several years. Market rents in the East Bay in general are rising. Economic growth and job growth has put pressure on the residential rental market all over the Bay Area, and it's pushing to Emeryville and the East Bay, particularly Emeryville because of its proximity to these job centers. This is a slide showing the rents, the average rents that have and how they've been going up over the last 4 years. You can see that they're going up about the same rate, whether they're a studio or a 3-bedroom. Recently, the 3-bedrooms have gone up even faster. Currently, the tenant protections that we have here in the city of Emeryville are tenant protections that are provided by state law. There's guidelines and rules on what can be in a rental agreement, how rent increase notices are done, how much you can charge for security deposit, and sort of how you do the security deposit process. There's rules about repairs and habitability, eviction notices, reasonable accommodation, and many other items in state law. In addition, the city of Emeryville contracts through the county with Echo Fair Housing. They do landlord-tenant conciliation and mediation. They do tenants' rights information, fair housing services, and education. Tenant protections beyond the state law that many cities have enacted are rent control. Rent control is a restriction in the amount and timing of rent increases, eviction and harassment protections, which restrict why a tenant can be evicted, and protect tenants from harassment as a means to evict tenants. There's also rent reviews and rent review boards, which require landlords and tenants to mediate rent increases, sometimes publicly. And tenant-landlord mediation, which makes mediation between landlords and tenants more available than it currently is. Because of the Costa-Hawkins Act, which was enacted in the state, there's very few units in Emeryville that would actually be subject to full rent control. And of those units, 158 of them are already below market rate units that have affordability restrictions on them. You saw the slide last week, but I've added some detail to it last Saturday. 38% of the units are owner-occupied units. Those would not be subject to rent control. 23% are condominiums or owner-occupied owner units that are rented out. Those are also not subject to rent control. Of the remaining renter units, 26% were built after 1995 and would be not subject to rent control. 2% are BMRs, already restricted, rent restricted, and we restrict those rents, and that'll be coming to you on June 2nd. And then 11% of the units would be subject to rent control, approximately 700 of those. And as more and more rental housing gets built, that percentage will go down because we can't add to buildings any more units that were built before 1995. I want to talk about a little bit about eviction and harassment protections. In eviction protections, the landlord must state and prove a valid reason for termination of month-to-month tenancy. Tenants are protected already from eviction if they have a long-term lease, but most leases turn to month-to-month at a certain point, and then eviction protections protect those tenants who are on a month-to-month lease. The ordinance that we might craft would specify what would be considered a valid reasons for eviction. The ordinance also specifies which units would be covered by the protections. You can cover just rent control units. You could cover units built by a specific date. That's how Oakland does it. Units built in multifamily buildings but not condo mapped. Or all units rented in the city could be covered by eviction defense. There is actually some debate as to whether eviction defense is a very useful tool in the absence of rent control, because landlords would be able just to raise the rent as a means of evicting people. But I believe there are some remedies for that. And then when you have eviction protections, sometimes landlords will actually harass tenants as a way of removing them or sort of forcing them to move, and also a way of avoiding the rent control restrictions. So harassment protections protect tenants from being harassed out of their unit. Rent review is a type of alternative to rent control that some jurisdictions in the Bay Area have instituted. It provides a public forum for tenants to discuss rent increases. It generally includes a requirement or an opportunity to mediate between tenants and landlords before that public forum. It may or may not have an appointed rent review board, or it may or may not be able to appeal to the city council, depending on how the ordinance is written. And due to Costa-Hawkins Act, rent review boards do not have any binding authority over non-rent controlled units. Tenant-landlord mediation is a disinterested party that the tenants and landlords can discuss. They can do conciliation and mediation regarding a variety of disputes, of which rent increases is one. We've done an estimated cost of the tenant protections program, depending on what level of protection and what type of ordinance the council would like to look at. not going to go into much detail. And then there's possible revenues. So depending on what units, how the ordinance might be written, there are certain revenues that you can get from depending on how many units are covered. So tonight we have some discussion questions for the council, starting with increasing the funding to the landlord-tenant mediation contractor. This is something the Housing Committee recommended. So add evening hours in Emeryville so that Emeryville tenants and landlords can meet with mediators, just to make it more available than it is now. Currently, it's kind of a call-in, and there's not a lot of staff associated with Emeryville. This second thing is develop a rent review ordinance that covers all Emeryville tenants and encourages voluntary negotiations between landlords and tenants related to rent increases. And it might include tenant harassment or hire a consultant to analyze the issue related to the development of a rent control ordinance for those units that are legally eligible for rent control. And that may include protections related to eviction control and or tenant harassment, or some combination of these things. That's the end of my presentation. I'm here for questions.
Council?
Can we hear from the public, or?
Well, I'll take clarifying questions first.
No questions yet.
Okay. Public comment on this? John?
Is it 2 minutes or 3 minutes, Mayor?
You'll get 3.
3? Oh, thanks.
I don't see I don't have a whole
It's not a
list.
long line of us for this one.
Yeah.
John Bowders, resident. Just wanted to thank the city for considering this. We've discussed these issues at the Housing Committee, and I wanted to provide just a little context of some of the things that were reviewed for you. As an attorney who represented probably close to 3,000 people in landlord-tenant matters over the last 10 years, some of the types of behaviors that we're trying to prohibit with these types of ordinances are much more common than people might think. And there's some particularly vulnerable individuals who would be benefited from these. And so if I was to make a recommendation to you from the perspective of an advocate and somebody who has worked with people who'd benefit from this, my first 2 suggestions would be the Just Cause Ordinance and a tenant protection ordinance that covers anti-harassment provisions. The Just Cause Ordinance basically protects people in month-to-month tenancies in particular. Oftentimes those are people who are on lower fixed incomes, seniors, or people with disabilities, and it allows us to enumerate specific types of people we want to have protected who've lived in a building for a long period of time. I hate to say this, people don't want to believe it happens, but I've worked with people who had terminal illnesses, who had a utility shut off because they're on an oxygen generator or some other type of machine, and the loss of service of the utility was a technical violation of the lease, and so we actually had landlords who would move to evict people for those things. Seniors who had a social security check get lost in the mail or whatnot. So basically this adds a level of protection for very particularly vulnerable people in the community, and you can craft it in a way that includes the types of people you want to specifically protect. So it's not a summarial bank list of things. It can be tailored to the types of people you want to protect. And then the anti-harassment ordinance, I know there is a debate, and I agree with what Catherine said about most people don't think that they're particularly helpful without rent control. I actually disagree in the case of Emeryville for a couple reasons. One, there are only so many units that are even eligible to be protected by rent control. But the rents are so high in Emeryville that even if you had rent control, or even in the absence of rent control, people are still going to be harassed one way or the other. They're still going to have problems paying their rent, whether that rent is increased or not. So not to take rent control off the table, it's just not the most immediate of the things that I would recommend you consider among the list that you have before you, because a tenant protection anti-harassment ordinance is actually a pretty substantive issue and would be best to be reviewed by a number of stakeholders. But it's very important to protecting people, and we have such a heavy resident tenant base in this community, and I've been saying this for a while now, but the city needs to think, when we've built in a flurry of time such a heavy housing stock, Just
Sorry,
to,
Joe.
that's okay. Just to consider that you have to plan for the future.
Mayor Atkins?
Yeah.
I have a question. Has the Housing Committee considered these questions?
Yes, the Housing Committee got these questions.
And do they have formal recommendations to the council?
They, as I said, they recommended increase the funding to the landlord-tenant mediation contractor. That was 5 or 6 months ago. And rents have actually been increasing, and people are, I mean, I get the calls. And so I think the situation has changed to some extent since then. So, you know, we could go back to the Housing Committee and bring it back to the Housing Committee, but...
Well, what I'm looking for is a clear recommendation of action that can be taken. We're really talking about a relatively small number of units in the city of Emeryville. What'd you say, 300?
700 for rent control.
700. It's a relatively small number, but each one of those 700 units, you know, are living, breathing people or who may or may not be in difficulties. How can we tailor what actions we do to that particular number of units that we can really do something about? Rather than use a broad axe, can we use a scalpel?
Well, I mean, the rent control, we could enact a rent control ordinance for those 700 units. There's a lot of details about what can be passed through, what cannot be passed through. So, you know, the Housing Committee would be very involved in sort of the detailed development of how that might work. And then for the rest of the 3,300 rental units in the city, you could do something as well. One of these choices.
That would be eviction control and anti-harassment.
Or a rent review sort of situation, yeah. Because there's two issues here. Eviction is when people are actually being, I got a call today, somebody was being evicted. There's a difference between being evicted and having your rent increase. There are people who call me who have had rent increases, but when I discuss with them their incomes, they're even with the huge rent increase, they're still not paying 30% of their income on rent. It seems very unfair to them, but in fact, it's not an unaffordable situation for them. But when somebody's evicted, they're actually removed from their home. And obviously harassment has an effect on people.
Can you explain what a just cause eviction is
Just
about?
cause is, I can go back. Just cause is when the ordinance says what specifically would be a valid reason for eviction, a just cause to be evicted. You need a cause. And that's, what those causes would be described in our ordinance.
Is it usually just non-payment of rent or property damage or something?
And criminal activity, yeah.
And criminal activity.
Yeah, right.
I'm not aware that that's such an issue here, but maybe it is. I don't know.
Eviction without cause, people do get evicted here, yeah.
Yeah, okay. Yeah.
How is the best way to move forward on this?
That's for us to decide.
Yeah, may I make a suggestion? Thank you, Catherine, for your report and for your fount of knowledge. And I know not every tool works for Emeryville, as Vice Mayor Davis said earlier tonight. We're an anomaly. That 11%, those are people that we can and should help, but I think we should take a smart tact at doing things, and I think Mr. Bowders was onto something. If we create a foundation of protecting all of our tenants in Emeryville and then continue to consider what we can do, if we should consider rent control in the future. But if we start with a just cause eviction ordinance and a tenant protection ordinance, that will cover everyone. And I think I would like to see this go back to housing. I think it requires a lot more discussion.
I would support that.
Yeah, but I think with the direction that we begin with a foundation to protect all of our renters and set the stage if we ever move forward with rent control, because it's a costly thing to do, and I understand that for 11% of our housing, we might have to examine it further, but there are things that we can do now that we can do for everyone to take a step in the right direction.
Okay, I do want to say one thing, since we're going in this direction. I want to give a little bit more detail on this. There are two ways to do eviction protections. One is to have an eviction protection ordinance, which is written such that a tenant who's being evicted can go to court and protect themselves. And there is a way of doing eviction protection where the city actually has hearing officers, similar to a rent control ordinance. Mm-hmm. And
would that be you?
It would have to be probably somebody with an attorney.
An attorney. Oh, okay.
Yeah, sorry. I mean, you want a hearing officer, essentially, somebody who, is aware of the law and how it. And we would have to, we write the ordinance, but then you actually have to write guidelines as well on how to administer the ordinance. So I'm just curious to know. If you have an idea of what direction you might want to go in that. If you want to have a city body, it would be a new board or a new staff person who would hear people's complaints about evictions, or if you would like it to be something that is done in the courts.
May I ask a question? Would this be a separate person? Would this person be able to handle harassment as well?
Yeah.
Hmm.
So, I don't know.
Well, I think let's try to let's move in the direction of just cause and an ordinance and harassment protections.
Okay.
I think this slide sums up something that could be a good start for a broad cross section. Anybody disagree with that?
No, I agree with that, and I think I would just like to understand maybe in greater in detail when this comes back to us, the difference between court and a hearing officer. I need more things to read, I guess. Okay. That's what I'm saying.
All right.
I'm not sure we're big enough to have to be able to do that in-house.
Right.
So.
Okay. Yeah.
And maybe with some of these costs are so high, it's almost like the city could just directly pay for helping some people who need something so that they are not having their power turned off while their oxygen machine is on. We gotta, there might be a more practical, direct way that the city could help out certain people under certain conditions that would be cheaper than having a whole huge department.
Right. So there is an organization, there's the Eviction Defense Center, and there's also the East Bay Community Law Center that help low-income tenants with issues. So perhaps it's a combination of drafting an ordinance and finding a contractor who will provide services and guidance for low-income people who are facing this issue.
Also, there's just the need for information and referral. I mean, there's PG&E assistance programs for low-income folks, and there's PG&E kind of allowances for medical equipment that draw on. So it sounds like people might not even be aware of programs and resources that are already out there.
Yes, and actually, with the 50 units that we're renting up at MEM Park on Powell, we're actually putting together some information for the tenants who are the very low-income tenants who are in those units.
Because PG&E has the CARE program. They also have a medical allowance thing and some other things.
Oh, yeah.
One more question. Catherine, would you happen to know where on our website people would get information about their rights as renters, or if there's not a place, then
well, in the community development department page, there is a housing section, and in that housing section, there's a link to tenant issues.
Can we maybe signal boost that to the front page, since we know that rent right now is something that, I mean, you're fielding a lot of calls. You're going to get more calls if we do that, but
I'd like to see a permanent place on the landing page.
Yeah.
And if I may, I think that there's attachment 1 in the packet Catherine put together. It's just kind of it's a fact sheet on tenants' rights. We've sent this out before, I think, in the e-news, so we can update this again and just kind of continually get the information out and think about. Yeah.
And it has the information on who to call for what. It's also once a year. It's in the guide.
Okay.
But we'll put it on our homepage.
I think we had the question about the mediator, though, and the increased hours. Did you need more direction on that? Or?
Well, we can give them more money, but do we have more business that's coming to them, or are they complaining that the Emeryville business they're getting our reimbursement for that doesn't cover the demand?
Well, they get $80,000 for the urban county. It's not a huge amount of money, so there's not a huge amount of outreach in Emeryville. So I discussed this with them and discussed that an outreach budget, as well as having office hours here in Emeryville in the city hall, and also making space available for them on weekends and evenings when tenants, who might not be able to come during the workday. So that's where I got that budget from, $10,000 to $15,000 with that proposal to them. But if the idea is to have a contractor who does assistance for the eviction defense, it might make sense for us to rethink that the whole thing. So I'll take a look at that and come back to you.
Yeah. So I think we have a direction to move in. I don't think there's any other additions.
Okay.
Thank you for your report, Catherine. It's meaty, and now we have some way to move. Okay. We have 7.4, resolution dismissing an appeal of Sonia Steverson regarding denial of the cardroom work permit.
So any person employed in a cardroom in the city must obtain a work permit in accordance with provisions of the city's code. Any person seeking a permit is subject to a criminal history background check. And the code identifies certain convictions as being a per se basis for determining that the work permit applicant is unfit to be employed in a cardroom, and then the code mandates that the chief of police not approve the application. Ms. Steverson submitted an application to work at the Oaks Cardroom, and the police department conducted a criminal background check which revealed prior felony convictions for possession of marijuana and narcotics for sale in several different instances. One of the enumerated violations in the code that is therefore deems the person unfit to be issued a employee permit is in fact a felony conviction for possession for sale of a controlled substance. So the police department denied Ms. Steverson's work permit application. Ms. Steverson submitted an appeal to the city council, as is her right that was provided in the denial letter. Upon receipt of a appeal, the council has two options. First, if in the opinion of the council that the facts stated in the notice of appeal do not warrant a hearing, the appeal may be dismissed immediately. On the other hand, if the council finds that the facts stated in the notice of appeal and the applicant's application constitute sufficient issues being raised to warrant a hearing in the public interest, then the council would then set a formal hearing on the matter at a subsequent meeting of the council and cause notice of the hearing to be provided to the applicant, the department, and the Oaks Club. Ms. Stevenson's appeal letter is in your packet. She states that her conviction that occurred in 1988, that there was no intent to conceal this conviction, and that she was advised that if the conviction occurred more than 10 years prior to the submission of her application, that it may not be the sole basis for the work permit. I would note that the basis for denial of her permit had nothing to do with whether she was making false statements, so it's somewhat immaterial as to whether she intended to or not conceal the conviction. Rather, the basis for the denial were the prior convictions for the felony convictions. And so with respect to those prior convictions, she indicates that she was advised, doesn't identify by whom, that convictions more than 10 years old aren't to be considered or should not be the sole basis. She doesn't identify whom told her that. Certainly there's no provision in the code that provides any exception for a prior conviction, no matter the time frame in which it occurred. And clearly the municipal code provides that if there is a felony conviction for possession for sale of narcotics, that is a sort of per se determination that the applicant is unfit. And so we're not finding in the appeal that there are really any facts that would warrant a hearing, and so we're recommending that the appeal be dismissed and no hearing be had on the matter.
I have some questions. Mr. Biddle, was the applicant notified of this meeting?
No, she was not.
That was my question.
Any other questions? All right. So
It is okay. So I guess I have a follow-up question. I haven't seen one of these before in my time on council. Is that usually the process, or how does that work? Do we notify people that this is going to be heard in chambers?
As I know you and I sort of discussed this. I can only remember maybe a couple of these in the time I've been here. So I normally do not handle these.
Oh, okay. Yeah. Okay.
And so this came in before the interim chief came in. So normally the police department handles these. So anyway, this came into the city clerk's office and had been sitting there. So I figured I better address this. But the basis for not notifying the individual is that their opportunity to set forth a basis for and provide alleged facts as to why their appeal warrants a hearing, which if you decide there should be, they would then be provided notice. But anyway, their opportunity to appeal that initial determination, they've had the opportunity to provide written facts to you within that time period, within that 15-day period after the determination was made, to sort of establish what the facts are. This meeting doesn't give them another opportunity to now sort of a second bite at the apple to sort of come up with additional facts beyond those which were required to be stated in the notice of appeal. So again, that's the basis for not providing them a notice of this meeting. Certainly if the notice of appeal that they submitted did provide and elicit facts that might support a hearing, then they would then be notified of a subsequent hearing to actually delve into the matter more.
is there any public comment? Yeah.
So my public comment on this is not to question the conduct of the city attorney or the police department in doing their review appropriately. It's simply to provide context in the absence of an appellant being here as someone who has defended people on this issue in applications for housing or employment. It's true that the code doesn't specifically call out, as the council members or the city attorney said, but actually under the Fair Credit Reporting Act, a common misperception among people, especially low-income people who have a record, they can only, third-party credit reporting agencies that report this information to employers or housing providers can only report information that's 7 years old or less if it's a misdemeanor and 10 years or less if it's a felony. Now, it's not the case in this situation, obviously, because this was an application to a city for a permit that the police department reviewed and wasn't a third-party reporter. But it is not uncommon for a person to have a misconception based on literally things shared within their community. That's not to excuse, I don't know the individual, to be honest with you. I'm not making a factual defense for the person. I'm simply stating that it is not uncommon at all for a person to have a misconception about this. And while we do send and give people notice and the right to appeal, and have done a lot of administrative hearings on these issues, and we do tie people to things that are listed in a notice of appeal. It doesn't really spell out for them what things they need to address. It simply says we're proposing to deny the permit for this reason. And what I've found in my experience is that when people get the administrative hearing and they have the opportunity to talk about the time, the facts, the circumstances that surround the actual event, it doesn't always appear the same way as it does on a piece of paper that evaluates them for being a felon in 1988. I mean, law enforcement agencies do have a lot of discretion in determining what constitutes possession with intent to deliver, and that's not to say that the judgments made by the law enforcement agents who made the arrests at those times was inaccurate or inappropriate. It's just to say that a lot of times you can find that a person has actually turned their life around and has been working for a number of years since an arrest, and we actually want, in my opinion, as a matter of public policy, to encourage those people to continue working in our community.
There was another, in the staff report, there was another conviction.
Yes, there was a conviction in 1988 for possession of marijuana and narcotics for sale. 1992, convicted for felony illegal possession of a firearm. Then February 1993, another felony conviction for possession of marijuana and narcotics for sale. And then in June 2004, for an undisclosed reason in the criminal history report, her probation was revoked and sentenced to 3 years in jail. And again, I just want to reiterate that whether any intent to conceal the prior convictions was not the basis of the police department's denial of the work permit application. It was merely based on the prior convictions. So whether Ms. Steverson had any thought or sense that somehow because it was an old conviction that it wasn't something she had to report or not is really immaterial to the
So
matter.
then, Mr. Biddle, can we, as a city, have an ordinance that says that we don't look at criminal convictions that are more than a decade old? Or I'm wondering here, like for me, I look at this and I think, okay, someone's had a conviction 10 years ago, maybe they've served jail time. I wonder why, in addition to serving jail time, they also are denied employment or screened out of employment. And I'm just trying to figure out what our role is as a city and where that decision lies in terms of how much history we take into account. Do we have any latitude? Not with just this case, I guess.
No, I understand where you're at, what you're asking. Certainly any revisions you would want to make to this ordinance, which deals with card rooms, would have to be submitted to the state Attorney General's office, their Division of Gaming.
Okay.
And I cannot speak authoritatively as to whether this provision is essentially mirroring state law. I just don't know that off the top of my head. I do know that this provision has been on the books for quite a long time. So,
Thank you.
All right, what's the pleasure of the council here?
I just feel like that we'd have to get involved in overturning an ordinance, you know, that it's about, we don't have a choice. I think we just have to go with what exists on that existing ordinance. Yeah, I don't see any, unless we change the ordinance.
Is that a motion, Scott?
Yes.
Second.
Any other discussion?
I think that while we may be doing the strict application of what our current ordinance reads, that I have a great deal of discomfort about it, I guess, and would like, if we're able to influence the process and think about people coming in and being, notification so that they can speak when their criminal record is being read into the public record, and other elements that we might be able to add to our process. Even if I can't add it right now, it's something that I want to flag and think about going forward. There's, this is something that's being considered in lots of places when it comes to felony convictions and talking about banning the box. And so I feel very limited by what's in front of me. And that's not, apparently it's been on the books for a really long time.
Yeah, so. and I would just add there's a great deal of sensitivity from the law enforcement aspect of permitting of employees who are going to work at a card room where there are certain criminal elements at play, and that is really the genesis for some of these provisions that may seem a little bit harsh. You really need to have a very relatively clean record to be able to work in a card room. Now, of course, the enumerated violations are, there's a long list of them, but they're not inclusive of everything that could potentially happen out there. So, but it really just looks at those types of violations where perhaps people are open themselves up or have shown a propensity to look at making a dollar at the expense of doing the right thing. And when you're dealing in a card room with such large amounts and large sums of money at play and being handled, that's part of the rationale, I believe, behind it.
Right.
I'm sorry, can we still vote to give this woman a hearing and get more information? Is that not what's before us?
We could continue this and invite her to come.
Yeah.
Put it back on the agenda.
But as a hearing, is that a yes?
Yeah, I mean, you have the alternative of saying, yes, I think that she has, in her appeal, has raised some issues that warrant a hearing. That's not our recommendation, but anyhow.
I just feel we don't have enough information. And I think a hearing would bring that information forth, and I think it would be helpful to have the applicant in the room.
Okay.
I'm willing to, I would like to do
let's
that.
try that.
So you want to grant a hearing?
Yeah.
Yes.
Then when would you like to hold this hearing?
When is our next?
When can we accommodate?
You certainly cannot do it on May 19th.
Yeah, Michael.
No, I mean, we just, the agenda's going out.
How about the first meeting in June?
We could probably make that.
Okay.
Yeah.
Okay.
Thank you.
Very good. All right. That takes us to
I'm assuming, is that a 5-0 or, okay.
Without exception.
Yes.
A hearing, yeah.
Okay.